This conference will now be recorded.
So I'd like to introduce Rita Armstrong of Aston Gardens of Parkland and thank her for hosting today's webinar. Rita, go ahead and unmute yourself.
Okay. So I just want to welcome everybody and thank Stephanie for doing this for us. Hopefully more people will join us as we continue. I know you probably already know about Aston Gardens, except for maybe Catherine. We are a senior living community in Parkland, Florida, South Florida. We have assisted living, independent living, memory care. We also have physical therapy on property as well as hospice. So we do cover pretty much all the care levels. We are a rental community. We do have assisted living starting at around $4,000 a month, independent living starting just under $3,000 a month. We do provide a lot of support services, meals, utilities, housekeeping, activities, transportation, maintenance. All of that is inclusive so that you can come here and pretty much live very comfortably with all of that support built into the lifestyle. We do have immediate availability right now in all our care levels. Due to COVID, it's been difficult to refill the building, so we are asking for referrals. If you know anybody that's looking for this kind of lifestyle, we would love for you to refer to us so that we can tell them a little bit more about our community. At this point in time, we are COVID-free, glad to say, 100% COVID-free, both in our independent living and our assisted living. We are, as I mentioned to Evan, we are allowing for visitation now, limited, of course, with social distancing and masks. We're trying to now come up with our policies on visiting by at least one family member who would be considered the official caregiver, along with our caregivers. And then that person would be allowed once to come into the building, wear their PPE, and spend time with their family member and allow for additional caregiving. So we're just working our protocols for that right now, and we'll get that tied up so that we can understand what that involves and explain that to our residents and their families. So as I say, we do have availability. We're hoping for some referrals so that we can refill our building, and hopefully we'll remain COVID-free, because if we don't, then we have to stop the visitation at least for 14 days. That's the new rule. So, but anyway, just if anybody does know of anyone, you can call me directly at Aston Gardens. My direct line is 954-323-6304. Or they could email me. And we are allowing for visitation and independent living with total tours. And I could also do a video for anybody who wants to get an idea of what the apartments look like, but they can't walk into the assisted living. We can do a video and provide that to the family as well. And then all the information that they're going to require before they make a decision. So thank you all for being here. Hopefully Stephanie has some interesting things that you can go over with us, and then I'll be available for questions if you should have any about senior living. Maybe after Stephanie's finished, if you have some questions, jot them down, let us know. Thanks, Steph.
Thank you, Rita, and welcome, Mickey. So today's topic is the top 10 elder law questions and answers in 2020, and this is my version of the David Letterman countdown for those of you that were a Letterman fan. So I've looked back at many conversations and meetings with clients and pulled the things that seem to repeat the most and be of the highest concern to most people as they're going through the aging process. So we're going to start with number 10 and count backwards. So the number 10 most frequently asked question has been, I can add my child's name onto my bank account and avoid a guardianship if I become incapacitated, right? Well, the answer to that question is not necessarily as simple as most people would think it is. Now, most people would say, I'll just add my child's name onto the account if I get sick, if I become incapacitated. They can just go in, talk to the banker, withdraw money, pay my bills, move money from one account to another. It's not as simple as that for a couple of reasons. Number one, if you put a child's name onto the account as a joint owner, what most people don't realize is legally they are giving that child equal ownership rights, and that joint owner does not need permission from the parent to go in and make withdrawals. The bigger concern that I share with people is the what ifs, the things that we never think are going to happen, such as our adult child getting a divorce, or perhaps having to file bankruptcy because their business did not do well, or they lived beyond their means. In those situations, the unfortunate result is that the child has to report to the family law court and the bankruptcy court the existence of the assets that are jointly owned with the parent. Now, when I explain this to clients, they're completely shocked and surprised, and their first reaction is, but wait a second, my child didn't contribute anything. Why does that account have to be reported in those court matters? And it's just simply because the child's name is on it, so they become a legal joint owner. So my suggestion is that the better approach to take is to have a well-written, durable power of attorney prepared for the parent. It's much safer because they're not making the adult child a joint owner. They're actually giving the adult child the responsibility and the legal access to handle the assets for the benefit of the parent. So in no way is the durable power of attorney making the adult child an owner or a joint owner. So I think it's much safer. The other thing that many people do not realize is just by putting a child's name on one account does not mean if you become ill or incapacitated, then that child has access to other assets. For example, if you might own some sort of a retirement account, such as an IRA, a 401k, maybe a SEP or a cafeteria plan account, you really want a durable power of attorney that gives specific permission to access those assets when the owner is incapacitated. The number 9 most frequently asked elder law question is, should I disinherit my child who has a disability and give their inheritance to their sibling to hold for that child? Now, I've heard this a lot in 29 years of practice, and usually the family conversation goes something like this. The parent says to the eldest child in the family, I'm not going to leave anything to your sister Susan because she has fill in the blank, intellectual disability, autism, cerebral palsy, and she really can't handle the money, and I don't want anybody to take advantage of her. So I am going to leave her share to you. And my intention is that you're going to set that money aside and you're going to use it to help take care of your sister. You're going to use it to buy services and products that are going to improve the quality of her life when I'm no longer here to take care of her and oversee everything. And similar to the last question we just looked at, parents don't think about the unforeseen, unanticipated events. What if that eldest child were to get a divorce? And now the inheritance is all in that child's name, and it's going to have to be reported again in the family law divorce proceeding, which means that here in Florida, we have a theory called equitable distribution when people decide to divorce. and absent being able to prove special circumstances, the assets are going to be divided equally between the divorcing spouses. So the unfortunate consequence would be that the soon-to-be ex-son-in-law is going to end up with half the money that was really intended to be used for the benefit of Susan. So it's much better not to take the approach of disinheriting a child who was born with a disability, or even one that was born healthy, but then there was an illness or there was a car accident. The better approach that we recommend is called a special needs trust. And we've actually been doing special needs trusts for probably close to 40 years in the elder law practice. And back in 1993, Congress gave us the ability to create special needs trusts for people that had lawsuit settlements. And they were concerned that the settlement may not last throughout their lifetime, and the cost of the care was very great. So since 1993, we've been able to prepare special needs trusts for people that have accidents and then settle their cases. But when it comes to parents wanting to plan for a disabled child's future, whether they're a minor under 18 years of age or an adult over 18 years of age, you want to be thinking about the special needs trust, because it's a nice, safe way of creating a management system to hold that inheritance, whatever it is. It could be a home, it could be a bank account, it could be life insurance proceeds. We can even direct that an IRA distribution or a 401k distribution go into a special needs trust so that the adult child with the disability does not lose their government benefits, whether it's Medicaid or perhaps SSI benefits. To keep those benefits, that child has to have very limited assets of no more than $2,000 and very low income. So sometimes a parent may have majority of their wealth in a retirement type of plan. And so there's a lot of products and services that the child can benefit from by inheriting either all or a portion of the retirement account. And by directing it into the special needs trust, they get the best of both worlds. They get the inheritance and they stay on their government benefits. And mom or dad, whoever's creating the special needs trust, can still, if they want, choose to name the eldest child to be the trustee who oversees the trust, makes the decisions about how to invest the money, makes the decisions about what to purchase for the child with the disability. But as a trustee, they're a fiduciary, so they're not an owner. That trustee is held to a high standard of care in taking care of the trust assets for the benefit of the trust beneficiary. So I'm still surprised, even though we're in 2020, that a lot of people don't know about special needs trusts. And so this is a secret we don't want to be a secret anymore. We want to get this information out to people. The number 8 most frequently asked elder law question is, can I leave everything I own to my children from my first marriage and disinherit my current spouse? Now, if you're chuckling, I get this question more than you'd probably tend to think I do. And we're definitely living in a world where there are blended families these days. People are in their second, third, or fourth marriage. There are children from former marriages or former relationships. And so there may be that feeling of wanting to distribute most or all the assets to the children and less perhaps to the current spouse so that it stays within the bloodline. But Florida decided many years ago that it needed to protect surviving spouses. So Florida changed what is called its elective share law. Now, we've had that law for a very long time, and it basically says that if a deceased spouse has disinherited their surviving spouse, then the surviving spouse is entitled to 30% of the probate assets. Now, what goes through probate? Well, what goes through probate is anything that is in a deceased person's own name without a joint owner and does not have a beneficiary designated on the asset, whether it's a bank account or it could be a retirement account, let's say. Well, about 18 years ago, there was a very interesting case that arose here in South Florida where a married couple went to an estate planning attorney to create their wills. And the attorney did wills for both the husband and the wife. This was a second marriage. There were children from the former marriages. And a few months after the work had been completed, the husband called up the law firm and scheduled another appointment, but he was the only one that came to the consultation. And he confided in the attorney that he did not want to leave his spouse anything. So at that point in time, under the old law, since the right to the 30% would only attach to assets going through the court process called probate, what the client instructed the attorney to do was to create a revocable trust for him. He transferred his assets into the revocable trust. And then, of course, as you might imagine, he passed away first unexpectedly. And the widow went to the law firm for the reading of the will. And that's when she discovered that he had signed a revocable trust and put all his assets into it. And under the law at that time, her right to the 30% didn't attach to the assets in the revocable trust. Well, as you might imagine, she was very angry and upset. She had been left with practically nothing to go forward surviving on. And she hired a well-known law firm who realized there was a problem here in the law. And so a bill was proposed, which became the new elective share law, which now says that that 30% can attach to assets in a revocable trust. It can also attach to assets that name somebody else as a beneficiary. So the new law is more comprehensive and better protects a surviving spouse from the deceased spouse trying to disinherit them. Now, if both members of the marriage or one member of the marriage does not want the spouse to inherit at all or wants them to inherit less than the 30%, then the couple needs to seek the advice of a family law attorney, preferably before the marriage takes place, and they would then agree to what is called a prenuptial agreement, which sets forth what rights each one has and what rights each member of the marriage is going to give up. If the couple does not do this before getting married, they still have the other opportunity to do it after the marriage ceremony is performed, and that is what we call a post-nuptial agreement. But again, both parties really should be represented by separate attorneys, so there is no possibility of one attorney not being properly and ethically able to represent what may be two very different interests and two different intentions. It's best for spouses to have their own separate attorney. So if there is no prenuptial agreement or no postnuptial agreement, then the surviving spouse's elective share right to 30% is going to go against all assets. So it's much more comprehensive now. The seventh most frequently asked elder law question is, will Medicare automatically pay for my stay in a rehab facility after I'm discharged from a hospital? Now, Medicare was created back in the 50s, and if you think about it, back then, people did not have the life expectancies they have today. We also didn't have the span of healthcare and nutrition options and exercise options that we have today, which has probably contributed to people living longer. So what most people don't realize is that Medicare is intended to pay for short-term illnesses, not long-term illnesses, not chronic illnesses. And what I'm referring to are diagnoses such as Parkinson's disease, Alzheimer's disease, Lewy body dementia, Lou Gehrig's disease. And so it's very important that people understand Medicare will cover short-term, certain days in a hospital stay. Again, we get a maximum lifetime. Once that is reached, we don't replenish those days. Medicare will cover physician visits, durable medical equipment, as well as hospice services. But there are limits with all of those types of benefits. So for Medicare to cover services and therapies being provided in rehab, first, the person must have a 3-day hospital stay. This is very important. And it's become more important in the last year or two because we are seeing hospitals not actually admitting people into the hospital, but they stay in the emergency room. They are treated in the emergency room, and then they're discharged. And unfortunately, under the Medicare guidelines, that does not satisfy the hospital stay requirement. So to be a strong advocate when you have a loved one who's going into a hospital, you want to advocate to have them actually admitted into the hospital. And you want the doctor to work with you or the specialist that is seeing them to make sure they're going to keep them for that 3-day requirement. If they're there 2 days and they get discharged and then go to a rehab facility, Medicare is not going to cover anything at all. It's not that they're going to cover a reduced amount, there just will not be coverage provided. Now, if they meet the 3-day hospital stay, then between day 1 and day 20, Medicare is going to fully pay the cost of the stay. Generally around day 20, day 21, the rehab facility is going to reevaluate the patient. They're going to see how the patient is coming along with the therapies. Could be physical therapy, occupational therapy, or speech therapy. They're going to see, does this person continue to need therapy, either to maintain the level that they've reached or to prevent decline. We don't want people going backwards to the condition that they were in when they got discharged from the hospital. Now, if the facility goes ahead and submits the billing to Medicare and the patient continues to need the therapy, then Medicare is going to cover day 21 through day 100 at an 80% reimbursement rate. The remaining 20% is going to be the responsibility of the patient. So this is another reason why we want to encourage people before they turn 65 to become educated about what Medicare provides and what it does not cover, and the importance of purchasing what is called a Medicare supplement. It's also referred to as a Medigap policy, and its purpose is to cover some or all of the gaps where Medicare stops, so that there's less personal financial responsibility for the patient. And I'd like to encourage everybody who's attending today's webinar to join me this Friday Friday's webinar is going to focus on how to be an effective advocate for a nursing home resident or a rehab patient. We're going to talk more about these rules and how we can learn to be strong advocates. The sixth most frequently asked elder law question this year has been, is it okay that my last will and testament leaves everything I own to my 3 children, but I only designated one child as a beneficiary directly on a large account? Well, more people ask this question than you'd ever think. And it's a great question to ask because it shows us the inconsistency between what the will says and the actual outcome of what's going to happen by naming just one beneficiary on that large account. Because of the discrepancy, the will is going to lose out. The will is not going to control the disposition of that large account when the owner dies. So let's say, for example, there's a bank account or even an investment account, and the owner put only John's name as the beneficiary, but there are 2 more children. There's a total of 3 children. Legally, when the parent dies and John walks into the bank or contacts the financial advisor at the brokerage house and gives them the parent's death certificate, they're going to check the records and they're going to see that John is the only child named directly on the account as a beneficiary. And legally, the bank or the investment house is required to give that account to John. So even if the other 2 children were to show up with a copy of the will and say, wait a second, we're also beneficiaries in our mom's will, legally, they are not entitled to the account that has the beneficiary designation. Now, some people may specifically want this result because perhaps John took care of mom in the last few years. Maybe he became the primary caregiver, and this was her way of rewarding him for taking the time. Perhaps he had to reduce his employment outside the home to care for her. But if it's not intentional, then it's important that people understand they're going to create a different result because the will says one thing and the beneficiary designation says something entirely different than the will. Now, sometimes clients, after listening to what the outcome will be, will say, but I'll just tell John to make sure that he gives 1/3 to each of his siblings. I know that he's going to do it. So that is what we call a moral obligation. Perhaps John promised the mom that he would do this after she passed away. But a moral obligation is not legally enforceable in a court of law. It's up to John whether or not he chooses to share that account with his 2 siblings. Now, John may be very ethical and he may plan on following what the mom has requested and what her intention is. But sometimes after a parent dies, disagreements arise in a family. We discovered that there's been sibling rivalry over the years, or perhaps jealousy or envy. Well, that may then cause John to say, you're accusing me of things that I didn't do. I'm not going to share this account with you. I'm going to keep it all to myself. So rather than create a situation that might actually lead to family disharmony or a family being broken up, it's much better to make sure that the designations on the account are going to match the beneficiaries who are identified in either the last will and testament or the revocable trust. Now, the fifth most frequently asked question comes about a lot, whether people are in a first marriage, a second marriage. As we grow older and perhaps we start to have different medical issues or we've had a diagnosis and we're going to need long-term care, it's not unusual for people who are in a second marriage to perhaps panic. Fear generates taking actions that don't always make sense or aren't always based on correct information. So in this scenario, a child is asking what can she do if her father's second wife refuses to disclose her personal financial information to help the stepdaughter qualify her father for Medicaid assistance so that she can help pay for the care that he needs. Because there's a fear of people being impoverished, of being left with less than they need, some people view the glass as being half empty rather than half full. It's not all that unusual for a second spouse to not want to disclose their financial information or to be afraid that perhaps their spouse's children are going to try to require them to use their money to support the spouse. So my suggested approach is to educate. The more information that people have, the more likely it is that they will make proper decisions based upon fact and not myths, not rumors that they heard from a neighbor or misinformation that they got on the internet. So my first suggestion is to encourage that second spouse, whether they're the wife or the husband, to meet with the adult child and an elder law attorney so that they can become educated. By being educated, we can take away the misinformation about that spouse thinking that they're going to be left with nothing to take care of themselves as they age and go through the aging process. And it then opens up the door for us to talk about the legal options to not only help the father qualify and make sure his needs are met, but to also simultaneously make sure that the second spouse's needs are met as well. Now, if for any reason that second spouse doesn't want to attend a meeting with the adult child and the elder law attorney, or they've attended the meeting, but they still are not comfortable or they're suspicious, perhaps, of the adult child's intention, then the other option that we would explore is called spousal refusal. Now, this has been written in the federal law for many decades, and it is a federal law that Florida and every other state has to honor. And what it means is that when the Medicaid application is filed, there will be a document that the father or somebody who has legal authority to act for him through a power of attorney will sign that says, my spouse is not using resources to support or take care of me, and any rights I have to support, I am assigning to the state of Florida. There's a second document that will need to be signed by the spouse saying I am refusing to make my assets available for the support of my spouse who's applying for Medicaid. Now, what happens as a result of these two documents being signed is that when the Medicaid application is filed, the caseworker will send those forms up to the legal department to review, and they will process the application as if the parent, the father here in this scenario, is a single unmarried individual. So the caseworker will just look at the father's income and resources to make sure that he meets all the Medicaid eligibility requirements. If he does, then they're going to approve the application and he will receive Medicaid assistance. Now, this is not the same result that happens in other states such as New York and California. And we find that in those states that have better funded Medicaid budgets, they have better staffed Medicaid offices than we do here in Florida. What happens is the application will still be processed as if the applicant is a single unmarried individual. However, the legal department for Medicaid will send out a demand letter to the other spouse, asking that spouse to pay a certain sum, after which Medicaid will pay the facility. If that spouse either refuses or just doesn't respond to the request, what has happened in past years is the Medicaid department will file a lawsuit against that surviving spouse seeking support. Those cases do not go to a jury. They do get settled for cents on the dollar because nobody is going to want a case like that to go before a jury of their peers, where people are going to be of similar age, perhaps similar medical conditions, who would empathize with that second spouse. So those cases settle, and then Medicaid pays the facility. Now, here in Florida, one of the reasons that I believe this does not happen is because we do not have a legal right to support when it comes to medical needs. So, for example, if we have a spouse that goes into a hospital and receives services and treatments and gets discharged, and the bill is $20,000 and not everything is covered by insurance, the hospital can't require the patient's spouse to pay the bill when they didn't receive the services. There's no obligation of the spouse to support the other spouse and pay for their medical needs. So that is possibly why spousal refusal works the way it does in Florida, and the person's application is approved once all their eligibility requirements have been confirmed. So this is an option for people who are in second or third marriages, even those who are in a first marriage. But of course, we would prefer to first make sure that everybody has correct legal information before deciding to go that route. The fourth most frequently asked elder law question is, what's going to happen to a parent's Medicaid benefits when her home is sold or when she receives a settlement from a lawsuit? Now, the house in Florida under our Medicaid rules is protected, which means we don't count the value of the home when somebody needs Medicaid to pay for long-term care services. However, when the home is sold, the proceeds are cash, and cash is a countable resource. So we have to be prepared, and we have to think ahead of time as to what can we do so there's no loss of Medicaid for any amount of time. So we've got some wonderful options here in Florida. One option is that the proceeds from the sale of the home could be placed in a special needs trust, and that way the individual who's receiving the Medicaid has no direct access or control. So when it's properly done, the Medicaid office will not count the special needs trust assets as a resource, and the parent will maintain their Medicaid assistance. We have a second kind of special needs trust here in Florida that is called a pool trust, and this is able to be used for people that are over age 65, whereas the special needs trust can only be used for individuals under age 65. We might also use the pool trust if perhaps the proceeds from the sale of the home are minimal and we want to save on the administrative expense that's involved with writing the special needs trust and administering the special needs trust. So a pool trust is an opportunity for multiple individuals from around the state of Florida to pool their monies into this trust where separate accounts are maintained, but the monies can be grouped together, pooled together for investment purposes to yield a better rate of interest. Now, one thing to understand about these types of special needs trusts is that the government does not give us anything for free, so there is always an expectation attached. And written into the federal law for these trusts is the requirement that when the Medicaid recipient passes away, any monies remaining, or any assets for that matter, remaining in the trust must first go to repay the Medicaid lien, all the benefits that were paid over the individual's lifetime. Once the Medicaid lien is satisfied, then if there are still assets remaining in the trust, those can go to designated beneficiaries, whether the person designated family members, friends, charities, all of those are potential beneficiaries. But first we have to satisfy the Medicaid lien. Now, if there's no assets left in the special needs trust or the pool trust, that's fine. Medicaid doesn't get repaid, and nobody in the family has a legal obligation to repay the Medicaid lien either. So Medicaid is willing to take the risk that there will be some trusts where there will be assets left to satisfy the Medicaid debt, and there'll be trusts where there will not be monies left. So just be aware that there is this trade-off, but if all the monies are spent during the beneficiary's lifetime to give them better quality of care and better quality of life, then this has all been worth it. The other option that we can consider when the Medicaid recipient's home is sold or that person receives a lawsuit settlement is if there is a family member who has been providing services to the parent or the family member. For example, maybe they are overseeing or assisting in the care. Maybe they've moved into the parent's home, or the parent could even move into the caregiver's home. Those types of services we call personal care services, and those can be compensated when there is a written agreement that identifies all the different types of services the caregiver is providing. And we've done a calculation over the individual's life expectancy as to what the services are valued at using reasonable rates. So if there's a personal care agreement in place prior to the home being sold or the lawsuit being settled or right when it's happening, then the caregiver can be paid for their services going forward in time, but they cannot be paid retroactively for any services provided before there was a written agreement. So it is important to get the personal care agreement in place as soon as possible, even if there are no assets available to pay the caregiver. At least everything is documented, and when assets do become available, then the caregiver can be paid. The number 3 most frequently asked elder law question is, do I need to change my legal documents every time I move? I lived in New York, I did my documents there, now I'm in Florida, or I moved to Arizona. Do I really have to spend the time and the money to change my legal documents? And the answer is, generally speaking, no. And this is not just Florida law, but most states are going to honor legal documents that have been prepared in another state if they were properly executed. So whatever that state required for witnesses or a notary needs to have been followed. If the execution requirements were not followed and something is missing, then Florida is not going to honor those legal documents, whether it be a power of attorney or a last will and testament. And then new documents do need to be prepared. Now, one example I can share with you is that here in Florida, we require that a last will and testament have what is called a self-proving affidavit. And this is a page that goes at the end of the last will and testament, where it documents that the person signing their will was in the same presence as the witnesses and the notary, and that everybody saw each other during the signing. Without that self-proving affidavit, a judge will not admit the will to probate, and we actually then have to track down a witness and get them to sign an oath in the courthouse where they live. So some states don't require that self-proving affidavit. For example, I know that New York does not. So when people relocate from New York, we do recommend that they have a new will prepared that includes the self-proving affidavit. So years from now, when we have to admit the will to probate, we don't have to be concerned about trying to find the witnesses or what to do if for any reason the witnesses are no longer alive. The second most frequently asked elder law question is whether people can qualify for a program called Veteran Aid and Attendance Benefits if they have transferred assets. Now, for many years, the Medicaid eligibility requirements and the aid and attendance requirements were not the same. And so people might transfer assets and not qualify for Medicaid, but they could qualify for the Veteran Aid and Attendance Program, which provides them with a monthly financial stipend to help pay for, let's say, a home health agency to provide services, or perhaps they use that money to help pay for room and board in an assisted living facility such as Aston Gardens. Well, several years ago, the Veterans Administration felt that they needed to make their eligibility rules more of a mirror image to Medicaid's eligibility rules. And so a bill was proposed in Congress, and it literally took between 2 to 3 years before that bill was passed and became a law. So now, and this is since November of 2018, if somebody applies to the Veterans Administration for the Aid and Attendance Program, there is a 3-year look-back period. So on the application, the VA will ask the applicant, have you transferred any assets of value within 3 years? And you have to answer the question truthfully. You have to tell them what was transferred, its value, and when the transfer or the transfers occurred. They will then calculate a transfer penalty, what we refer to as a period of time that the applicant is ineligible to be approved for this program. And so the applicant will be denied. They will have to wait out that penalty period and then reapply after the penalty has expired. So this is a very important new rule that people need to be aware about. Otherwise, they're going to be taken by surprise when they apply and they get a denial notice. So not only is the Veterans Administration looking at the person's net worth, not only are they looking at what their income is and how their income compares to their out-of-pocket unreimbursed medical expenses, but they're now paying attention to whether there were transfers of assets in the last 3 years. So it's very important that people get the right counseling. And when I say the right counseling, I mean by individuals that have been accredited by the Veterans Administration to be able to provide the proper advice as to what the aid and attendance rules are. There are a lot of individuals and companies here in Florida that have popped up in the last few years that advertise to the public in a very misleading way to get people to think that somehow they are part of the Veterans Administration when they are not. There's nothing that they can do to shortcut the process, and there's nothing that they can do to prevent a transfer penalty from applying. But what they do is they take advantage of veterans and their spouses by charging them to help them with the application process. And this is forbidden under the VA rules. Even the accredited agent cannot charge for completing an application for any type of veteran benefit program. That is illegal. So if you hear of somebody that is about to work with a company and they're being charged to do the application, tell them to run the other way. They should not be paying a fee for help with the application. In fact, every county in the state has an office that is staffed by retired veterans that can assist with this. Here in Broward County, that office is called the Broward County Elderly and Veteran Services. And not only will they help people who are capable of coming to them, they will go to the veteran. So if the veteran is, let's say, in a hospital or is in a facility and can't be safely transported, somebody from that office will go to the veteran and sit and help complete the application. And last but not least, the number one most frequently asked elder law question is, will I lose my house if I or my spouse applies for Medicaid? And believe it or not, there's still a lot of rumors, a lot of misinformation that is given to people, not just on the internet, but even in hospitals when they're being discharged. They are incorrectly told they're going to lose their house, their family won't have a place to live. And unfortunately, when misinformation like that is given out, what people then do makes the whole situation worse. Many people will then go to an attorney, more likely a real estate attorney as opposed to an elder law attorney, and they'll have a deed prepared and they'll transfer the ownership of their home out of their name or out of their name and their spouse's name, and they'll transfer it to their children or somebody else in the family. And they're thinking all along, I just saved my house, and in reality, they just created a bigger problem because they transferred assets that will delay them being approved for Medicaid. So if you walk away with nothing else but this today, know that Florida has wonderful protections for the homestead. Most people only know about the protection we get when we see our real estate tax bill. And we see that we've gotten our ad valorem tax exemption that reduces the appraised value that the real estate taxes are calculated on. But Florida's protection is much bigger than that. We protect the home when the owner applies and gets approved for Medicaid assistance, even if the owner is going to go into a skilled nursing facility. They don't lose that homestead protection. Medicaid is not going to take the house. That's a fallacy. They're not going to force the owner to sell it and pay the proceeds over to Medicaid. That's another piece of misinformation. So no Medicaid lien is going to attach, even at the death of the Medicaid recipient, so long as the house will be inherited by a surviving spouse or by children or by what we call heirs. And heirs simply means people related by blood, even if it's further down along the bloodline. The only time that the home is not going to be protected when a Medicaid recipient passes away is going to be if they are leaving the home to somebody that is not related to them. So for example, if the Medicaid recipient has a domestic partner, they never got married, so in the eyes of the law, they are not a spouse, the Medicaid lien can attach. Or if they leave it to their best friend, again, they're not married to them, they're not related by blood, then the Medicaid lien could attach to the home when the owner dies. But overall, the home is protected both when the person applies for Medicaid and it remains protected when they pass away. So at this time, I would like to invite people to unmute their microphones and ask questions of either myself or Rita.
I have a question for you, Seth. You had said that there was a 3-year look back on VA. So is there a 3-year look back on Medicaid now? They're the same?
No, they're actually not the same. And thank you for asking the question, Rita. For several years now, the federal law has been there's a 5-year look back when somebody applies for Medicaid assistance. So that's 60 months. We do anticipate that in the next few years, we probably are going to see the Veterans Administration look to change their transfer rule to be exactly what the Medicaid transfer rule is, which is 5 years.
Okay, get it. And on the other point that you made about Medicaid possibly coming to get the house if you owe money when it's all finished, I would say then that would behoove the family to try to sell the home prior to that person going and taking Medicaid, getting Medicaid. Unless, I guess, with the last point, you're saying as long as it's being left to the family, then that's not a problem. But if they were going to sell the best thing to do would be to sell it prior to applying to Medicaid.
Well, not necessarily. You know, there is, when we talk about long-term care planning, there is no one-size-fits-all plan that works for every person. And the reason there isn't is everybody has a different financial situation and a different set of family dynamics. So a person's marital status can impact, whether or not they have children or they have a spouse can impact as well. You know, if the people that are eventually going to inherit the house are in a financial position where they can carry the ongoing costs, such as the utilities, the real estate taxes, the homeowner's insurance, it may make better sense just to leave the house titled in the parent's name. For other families, they may not be as financially fortunate. So we might explore for that family possibly renting the home just to be able to cover the carrying costs, and the house still remains protected and there's not going to be a Medicaid lien attaching to it when the parent passes away. So it's about finding the right solution for each individual.
Okay, got it. Very interesting. I'm happy to hear about Broward County elder law because we do have a lot of companies that we refer to people, and I know they charge. They do it under the idea that, you know, obviously it's estate planning, but they do for doing the report.
Okay. Would anybody else like to ask a question? Or you do have the option of using the chat box. It's that little icon that looks like a speech bubble. You're welcome to type a question in there.
The only thing I would want to add to that is that, you know, coming from the banking industry before I went into home care, since '95 I was in the banking industry. You'd be surprised how many families to this day get it wrong when they come to the bank. And they used to, as being as a regional, I used to get complaints from our customers saying, well, I added my daughter, my son, or I didn't add them. So it really starts with all of us, even myself in the home care, because the first thing I do when we do the living room visit is I try to educate them, ask them if they have a trust, they have a will, who's in charge, what happens. You would be surprised that even at these times that people do not have their teeth crossed and their I's dotted. And it was very, very eye-opening with a lot of questions that a lot of people still ask us that I can't answer, that I might be able to, you know, send to you, Stephanie. But thank you for doing that.
Absolutely. Well, thank you for sharing your insight and your experience.
You're welcome.
Stephanie, I have a question about the aid and attendance. I agree with you. There's a lot of people out there that are quite shady in presenting assistance to the veteran. And being a veteran myself, that just really makes me angry. What do you think about the companies that will process the application and then at no cost, and then we'll add a couple dollars to the bill rate of, say, the agency, and that's how they get funded?
Well, you know, every time there is a change in the law on this issue, and several years ago, Catherine, the Florida Bar Elder Law section went to our bar president, and we then went to the Florida Supreme Court to bring to their attention the level of abuse that was going on, not just with, you know, helping people qualify for Medicaid, but even for aid and attendance benefits. They did come out with an opinion of what constitutes the unauthorized practice of law. And the issue isn't so much, you know, helping somebody fill out an application. The issue is that they're charging them one way or another, whether it's upfront or in disguise. And the bigger issue is that these people are not qualified to be counseling and giving advice. And many of them have actually tried to sell products to the individual, whether they're a veteran or they're not a veteran, and convince them that by buying the product that they're selling, you know, whether it's an annuity or another kind of financial product, that they're going to qualify. And really, the person who is benefiting here is the person making the sale.
Sure.
So all of us need to continue to be watchful. And when we see these things happening, we do need to report it, because it's the only way we're going to get it to stop.
And who do we report it to?
Well, my first suggestion is you would contact the Attorney General office in your county. Every county has one. And then we have an Attorney General for the entire state.
Okay. Okay, great. Thank you.
Good question. Thank you for sharing, and thank you for your service, Catherine.
You're welcome. Thank you.
Does anybody else have a question or a comment that they'd like to share? So I want to thank everybody for joining me and Rita, and especially a big thank you to Aston Gardens for sponsoring today's webinar. As I mentioned, it is being recorded, and in a day or two, we will have that recording up on my website, so you're welcome to access it. I've provided you here with the link for how you can register for future webinars, as well as there will be the page where the recordings can be found. So you're welcome to share that. And you can always reach me either by phone, 954-382-1997, or by email, sschneider@fl-elderlaw.com. And Rita and I want to wish all of you a very healthy time going forward. And remember, please practice self-care. Take care of yourself so that you can be there to take care of others. And we wish you a wonderful week.